Welcome everyone, and I'm very happy to see so many of you coming to this workshop when there are so many interesting activities happening at the same time. This workshop has a very timely fashion, which I would like to say that was carefully planned, but we were ready, but we got a little bit lucky as well. The AI Act was approved yesterday, and this is most likely the first, let's say, technical presentation of that very important piece of legislation that is happening worldwide since its official approval yesterday. So this is quite exciting. It's very relevant. This is happening within the roboticist community of robotics. And so it's a great honor for me to be here with you today and to have such special guests, like you'll see in a moment, here with us to discuss such a relevant matter and how that is going to impact your life to some extent, possibly also in a positive sense, but certainly it's going to make a difference. And also, we would like to introduce you to some of the work we have been doing with my research team and some other of you that are here present with us today, in order to ease your life as roboticists and help you get ready for emerging European legislation. So let's start this workshop on getting ready for the AI Act. This is a brief plan of our 1.5 hour together today. So we'll start with a very short presentation by myself. I'll try to explain to you why, despite being roboticists, you're all doing artificial intelligence. Then we'll have a video recorded message from Brando Benifei, that is a member of the European Parliament from Italy, who was responsible for the AI Act. Brando, of course, couldn't come here today himself because, given the approval yesterday of this piece of legislation, he's submerged with press interviews and releases. And then we have a very qualified and skilled commentator, Tatiana Evers, that will connect with us directly from the European Commission. Tatiana, I know Tatiana since many years now. She's also known to this very community. She has been working on a number of initiatives that are related to advanced technologies, and currently she has been working on the drafting of the AI Act itself, and she will provide us a bird's eye view of the AI Act. Then we'll have a question and answer session where you're all more than welcome to intervene. And then we have a roundtable where we'll present exactly what I was mentioning to you before, namely the output of this project called RegulAIte, where there is an AI in between, standing of course for artificial intelligence, which will introduce to you a series of video lectures that we have prepared for the purpose of getting engineers up to speed on the most relevant topics of AI and technology regulation. So, as I said, the AI Act was approved yesterday in its final vote from the European Parliament with a vast majority. This is a huge milestone for Europe and the world alike, because the AI Act is the first piece of legislation worldwide systematically addressing artificial intelligence. It is part of the European regulatory effort that started in 2018 with a communication from the European Commission that described the European approach to artificial intelligence, which is human-centric and intended to respect the rights of European citizens that are very much at heart, while favoring innovation. And based on that statement from 2018, a number of initiatives started. The AI Act is by far the most relevant one. It's not the only one. In these very days, also the reform to the Product Liability Directive, which is the most important piece of European legislation addressing civil liability, was approved, and that will also affect anyone doing technological innovation, because that from now on will also apply to anything software. That piece of legislation is also addressed within the video lectures that we have prepared for you. So what is the European Union trying to do? Of course, the European Union is trying to favor innovation and also help protecting European citizens and their interests. And it's also pursuing the so-called Brussels effect. Getting there first is the idea of the European Commission, will help creating a European model, a European approach that might become the new global benchmark. This has happened up until today with the GDPR, the regulation addressing privacy and data protection, that you're probably all well aware of, which became very fast a global standard, exerting influence way beyond European borders. Unlike a typical piece of legislation which is only applicable within the territory of the state or supranational entity in the case of the European Union where that would apply. So as the GDPR became basically the global benchmark for data protection worldwide, the bet of the European Commission is that the AI Act will do the same. So this is also to put things in perspective. The move by the European Commission is a bold one. It's intended to make AI-based products safe, ease innovation, and create a global standard that others will have to comply with in a way or the other. So then we'll have to see if this plays out as it was originally intended by the European Commission, but this is a different story and we'll only be able to tell it in perspective a few years from now. Now, let me spend a few words why within a, even if it should be obvious by now, but why within a robotics conference and a roboticist community, so much emphasis is put on artificial intelligence. And my way of putting it is, even if you don't know it, you're all doing artificial intelligence. What do I mean by that? If you look into the definition of the AI Act for AI systems, it defines an AI system as a machine-based system designed to operate with varying levels of autonomy that may exhibit adaptiveness after deployment, and that, for explicit or implicit objectives, infers from the input it receives how to generate outputs such as predictions, recommendations, or decisions that can influence physical or virtual environments. So basically, the definition of AI that is advanced by the European Commission is a very broad and I would say all-encompassing definition. We can discuss whether this is the best definition of artificial intelligence possible. There has been a huge debate on this very matter for a long time, but of course, if you want to come up with the legislation, you have to define the object that you are trying to regulate in the very first place. So having a definition is unavoidable. And I really do believe that all of this that you're very familiar with is AI-based systems or applications. I took these very pictures today during the exhibit, and it's just a very small sample. I could have taken 100 more pictures. But all of these applications clearly fall within that definitions because they do display some degree of autonomy, they can impact the external world, they can exert an influence on the physical and also non-physical world in various ways, in different fashions. So I think it's quite obvious, without much more discussion needed, that all of this falls within the very broad definition that I have mentioned to you. So this also entails that the AI Act applies to you and to the kind of research and products that you're trying to develop, design, and distribute on the market. And so this means that everything what we're going to say today directly affects you. When I started being part of this community back in 2013, there was some difficulty in understanding how regulation impacted on your life. But this is becoming ever more obvious. And it's not meant in a negative sense. Regulation doesn't need to be a constraint. Regulation can also be something that helps innovation, favors innovation, so long it's well conceived. Moreover, some of the applications that you develop will be high-risk applications, those that encounter greater restrictions or that have to undergo greater scrutiny. We'll hear about it from Tatiana herself. But if we take the definition from the AI Act, it's a very long and complex and articulate definition, but among others, also applications that are either a safety component or a product itself that falls under these European product safety legislation and is also subject to third-party assessment, all such applications could be deemed high risk and thence be regulated, let's say, more heavily by the AI Act. Not prohibited, but regulated more in a more stringent fashion. And you see that the machinery directive is up there, the medical devices regulation is up there, and many others that are your bread and butter daily, because you all deal with these pieces of regulation. So this is why this all matters to you. This is why this all will affect you in a way or the other. This is why you need to start understanding all of it, and also start seeing the so-called unknown unknowns. So those things that you don't know that you don't know. So without any further ado, I will now leave the floor to Brando Benifei, that will be present just through a video recorded message. And chiedo alla regia di mandare il video. Brando Benifei was the person responsible for the member of the European Parliament that was responsible for the AI Act and its debate within the European Parliament. So, chiedo alla regia di mandare il video.
Thank you for the invitation. I'm sorry I cannot be with you, but I'm trying to give you some inputs on the work that we have done on the AI Act. My name is Brando Benifei. I'm the co-rapporteur for the whole Parliament of this Act that finally was voted in the European Parliament, exactly from this building in Strasbourg. The European Parliament sits here in these days. And we finally approved the first law in the world that regulates AI, looking at the risks of the use of artificial intelligence, trying to minimize those risks, and instead enlarging opportunities and building trust. Unfortunately, still too many people, with some reasons, but also with some unnecessary fears, are scared of the use of AI in our life, in the workplace, in everyday activities. So the objective of this law is to build more trust, and this clearly is intertwining with the machinery regulation that is now coming into force with the work that has been done to modify the previous legislation. There is a lot of interaction when we look at how machines and automated machines, and so robots are being put in place with AI components. It will be important to fine-tune this interaction. We have been working on that while also the other legislative file has been proceeding. And now it's very important that we start the implementation of the AI Act so that the businesses that develop AI components, also those that are linked to robots, in maybe especially of your interest, are ready to follow the rules when they become fully mandatory. Because the rules around the application of AI rules, of AI norms that we developed at European level with this AI Act is in the context of a calendar of time that is not immediate. At the beginning, there will be only voluntary obligations. The whole law will not be fully mandatory from the beginning. Only after 6 months from the final entry into force, we will see the prohibitions kicking in, the prohibitions on some use cases that we thought were too risky. So biometric cameras in public spaces for surveillance, except for the use for in real time, except for the use against for the search of criminals and victims of particularly terrible crimes. And this is one example. And then we prohibited the predictive policing. We prohibited the use of emotional recognition in workplaces and in places of study. We have also decided to prohibit social scoring in Chinese style. At the same time, we must say that after the 6 months time for the prohibitions to kick in, we will have a bit more than 1 year to see the transparency obligations enter into force. This is an area of our work that has been especially done, especially written by the European Parliament. I'm referring to transparency obligations like recognizability of AI-generated content and the copyright protection. And also the safety of the most powerful models. This is something that has been at the center of a lot of negotiations because a lot of interests are at stake on this. But if you think, for example, of the challenge of disinformation, it is extremely important that we have the way to make this content that is AI-generated always recognizable through a watermarking, an invisible labeling. Then we have also, after 2 years, the full mandatoriness of the risk reduction system that will come into place. This means that we will see the use of AI in certain areas, medical activity, doctor and patient, administration of justice, the workplaces, the democratic procedures. These are some examples. In these areas that are considered more sensitive, that are considered high risk in our text, the rules will apply for the developers of AI so that to enter our markets, they will need to comply with a conformity assessment. They will check data used to train the AI system, cybersecurity, human control, etc. Why 2 years for this more general risk reduction system? Because we need to develop standards. This will be very important that we do it also with the business sector that is involved with the standardizations organizations, the academia to work on this. So we need a bit more time for it to be completely, we can say, legally clear and fully applicable in the same way. But that's our objective. The objective of this regulation is to avoid the conundrum of recommendations of codes of practice that we have seen until today on AI. We want on those areas, I briefly explained, you see that we concentrate on most risky AI use cases, on transparency. In these areas, we want AI to be safer and for people to be able to believe that we are protecting them through adequate legislation. So this means also that we will need to see in Europe a work on conformity assessment, on checking also when a use case is prohibited, when we deal with AI that is used with robotics. As I said, there are other laws that will come into place, for sure, the machinery regulation that will build on how we can do our activity in Europe with these technologies in a safe way. This is the idea behind all this work. We are convinced that we can build a European model for AI development with these rules, but for sure if also we do what is missing today, which means a permanent and well-organized training on AI all over Europe, more sharing of the supercomputer computing capability at European level, which today is still not working together enough. There is a recent letter of scientists of Europe about the need for our supercomputers to work together more effectively. To invest more together, we need a united union of the capital markets if we want to see investment in this area to grow. We need to do more research together. So I think this issue of where Europe is heading will be very important and it will be necessarily debated in the next months, it will be very important to see if we can build a competitive edge on AI, maybe specializing on some areas as Europe. Time will tell, but I think that it's important that we work together on starting the compliance of these laws even before they become fully mandatory. This will be our effort also with the European Commission. We will start an AI pact that will accompany the business sector and the institutions to apply preemptively this regulation, the AI Act, before it becomes fully mandatory. So everyone will be ready for when everyone will need to conform to these rules. I hope I gave you a brief but understandable summary of what was our work. Now, it's been a long story, but it's coming to the end. But now a new story starts. As I said, implementation, measures to build an industrial policy on AI, competitiveness. There is still a lot to do. And I hope we can work together as we did on this work, so that we can be sure that we can be at the center of this big technological change with our European model. Thank you very much.
Okay, so I think it was a very interesting introduction by Brando Benifei, which now leads us to even a more, let's say, in-depth and technical analysis by Tatiana Evas. Tatiana is a law school professor on top of being an officer of the European Commission working for DG Connect right now. We met over the years a number of times and collaborated in a number of events. And back in 2021, I was lucky enough to have her again for what might have been one of the first events where we discussed the first draft of the AI Act. So it was very important for me to get her on board, considering how she has been working all these years on the very drafting of the AI Act and can provide us a very detailed presentation and understanding of this very complex proposal. So I leave the floor to Tatiana Evas, and let's start. Okay, Tatiana, are you online? Tatiana, can you hear us? Tatiana, can you hear us? Hello?
Yes, I can.
Okay.
Hi, yes, I can. Hi,
Thank you so much. Tatiana, the floor is yours.
Okay, thank you. Without further introductions, yes. Okay, good afternoon, everyone. And in my presentation, I will briefly run through the so-called BERT view on AI Act. And of course, I cannot do justice in 15-20 minutes about introducing this new regulation, but I hope I will set the main pointers of what it's all about. So probably most of you have heard about this, but I'll try to explain what is exactly it is. AI Act. So yesterday was an important milestone. So today we are really speaking in the right moment, because yesterday European Parliament plenary voted on this regulation and has approved it with overwhelmed majority, with only minor percentage of members of the parliament who have voted against or abstained. So I think there is a general understanding in the European Union among co-legislators that this regulation is very important. And we already, of course, see that this regulation already has an important impact both inside the European Union, but also outside. So now I try to explain why that's so much hype about it. So first of all, European Union Artificial Intelligence Act, it's a regulation, so it's legally binding legal act which will apply to all member states. So it's like harmonization legislation. So it means it's not soft law, it means it's not a directive, It really means a legally binding regulation, and in that sense, in terms of comprehensiveness of the coverage of the AI Act, it's one of the first global comprehensive regulation on AI. So in that context, it's also the regulation which for the first time in European Union will introduce legally binding definition of what artificial intelligence system is, which I must say was not an easy task to reach what is exactly. So we were between negotiations took quite a long of time, because on one hand, the definition didn't want to be over exclusive, so excluding certain type of AI technologies, but we also didn't want to be inclusive that every automated decision making is covered. So to find specific characteristics which would, in short and concise way, would distinguish AI system from other systems was quite a challenge. And at the end of long discussion, the legal definition adopted in the Act is strongly relies on the OECD definition. And this was done on purpose in order to contribute to the kind of global convergence in understanding what AI system is in the also in international context. So that would be the first legislation in the European Union context which would define what is artificial intelligence system. Said that, AI does not regulate every AI system and every AI technology. Actually, one of the key elements of AI Act is really to contribute to innovation and technological progress while ensuring trustworthiness of the AI systems on the market. So for that matter, there are important principles which define the overall logic and function of European Union Artificial Intelligence Act. First of all, AI Act will not cover any systems which are in development stage. So the products which are in research and development, including in prototyping stage, before they put on the market are not covered. Of course, the ethical principles related to AI systems would still apply, and all other provisions related to data protection and so on, if applicable. So all existing legislation would apply, but strictly speaking, European AI Act will not apply to the pre-market stage of the product, which is important also to allow for responsible innovation and technological progress. Secondly, the Act follows very strictly, and that's where we're also actually in policy debate kind of pioneers. We have advocated very strongly for risk-based approach. Risk-based approach basically means that we don't regulate technology per se, but only the specific use cases of the technology, because one and the same tool can be used differently in different contexts. So what AI Act says ultimately that technology per se is not good or bad, it's the way you use technology, or in which context you use technology could be risky. So, and connected to that, we also kind of classify different use cases or use categories into different risk levels, and later I will show you the risk-based approach pyramid, which maybe some of you have seen, which actually classifies this exactly use cases of AI systems based on the risk. So this is risk-based approach, meaning we regulate only specific use cases of specific technologies, and the way the classification of risk I will explain a bit later. So another very important principle of AI Act is the life cycle approach, and it connects to product safety legislation logic. So those of you who are familiar with product safety legislation in the European Union, it has quite straightforward idea. So it means that any product, the product within the of course, the scope of the product safety legislation, before it can be put on the market, it must be checked for safety, for health and safety. So before the medical device can be put on the market, or before machinery can be put on the market, you need to have a CE labeling, which actually kind of gives this assurance that the system has been checked. So AI Act follows into that category. It will complement already existing product safety legislation, meaning AI systems which fall into the high risk category would have to go through conformity assessment procedure, and they would need to have a CE marking before AI system could be used on AI market. And here are two important maybe additions to product safety regulation. That's why you see on the slide enhanced product safety regulation, because traditionally product safety legislation from, for example, machinery regulation looks at the health and safety risks, but AI Act adds to this category explicitly fundamental rights risks. So for example, risk management system for AI system would need also to look at the risks to health, safety, and fundamental rights. And that's very important because we bring a new category of risks which would need to be addressed specifically for AI system through conformity assessment process. Maybe a few words on life cycle approach. So as I mentioned, the logic of product safety legislation that the product is checked for its risks to safe health, safety, and fundamental rights before the product is put on the market. But the risk management doesn't stop there, you know, and so life cycle approach means that the product is continuously checked through all its life cycle, and also post-market monitoring is in place through market surveillance authorities who continuously check whether the AI system is continuously safe and high-risk AI system is continuously safe and meets the requirements. So this is kind of a fundamental logical pieces of AI Act which define overall specific provisions, which I think really importantly shapes the overall understanding. Another point before I go a bit more into detail about risk-based approach and high-risk AI systems is to mention that AI Act covers AI systems, so use cases of AI system, prohibited AI systems, so systems, we focus on systems. But also in the last round in negotiations, we have also added a specific chapter on general purpose AI models. And we are clearly distinguished between system and models, and there are different rules between systems and models for also, among other things, for technical reasons. So this is also important that there are rules, the bulk of the rules for in their act are addressed to AI systems, while there are also specific obligations related to general purpose AI models. Now, if I just spend a few words on the risk-based approach, like I said, a risk-based approach means that not all use cases of applications of AI systems are regulated. We only regulate certain specific use cases. So on the top of pyramid is unacceptable risk. So there will be some use cases which are completely prohibited in the EU. So for example, AI systems which are used for social scoring or which use subliminal techniques to exploit vulnerabilities of people. So this will be prohibited, and this prohibition will enter into force already 6 months after AI Act becomes, will enter into application 6 months after enter into force of AI Act. So these practices will be prohibited, and the reason for prohibition is because we believe that these practices are against European fundamental values which we value in European Union, so it's not acceptable. The very big bulk of AI Act is actually focuses on high risk use cases, and what is high risk is defined in Article 6 and also in Annex what is now 1 and 2 of AI Act. So basically here the logic was the following. There are two big categories what falls into high risk. One big category are the products which are already subject to product safety legislation. So, like I mentioned, medical devices, machinery, automotive, and all the products which are now currently under union harmonized legislation are considered to be falling into scope of product safety legislation. So we just take this and bring it to AI Act, and basically AI Act says, so if the product is considered to be a product which requires third-party conformity assessment under existing sectoral legislation, and there are two cumulative conditions, so subject to third-party conformity assessment under the existing sectoral legislation, plus AI system must be a safety component of the product. So if these elements are fulfilled, then the AI system is subject to the requirements of AI Act. and I, in my next slide, show what are the requirements. So this is one broad category, the products which are currently already covered by the Union sectoral safety legislation. The second category is the list of use cases, which are elaborated in now Annex 2, which lists 8 categories of use cases where the systems, AI systems, considered to be high risk. So, for example, recruitment, for example, law enforcement, and other categories in these 8 categories. But again, to be very precise, with 8 categories, they are defined quite broadly, and within each category, we define more specifically application areas, so use cases, which then will fall into this high-risk area. Then we have another category, if we go down, for so-called transparency risks. This is about the AI systems which interact with people and can give the perception that you interact with a human when actually you interact with AI system. So for those systems, we introduce a specific article which puts so-called transparency obligations, where the provider would have to make it very clear that you interact with the AI system and not with a human being. And finally, the largest actually part will be minimum or no risks. So if the AI system doesn't fall into category of unacceptable risk, so prohibited practices, high risk, or transparency, then the system is not subject to the requirements of AI Act. And there, in this category of minimum or no risk, we encourage the voluntary codes of conduct, for example, by industry. So, for example, I don't know, use of AI system in the research. So this is about the risk-based approach, and I'm cautious of time, so I'm just very quickly show you the requirements which will be applicable to high-risk AI system. They are quite traditional, I would say, most of them for the regulated products. So it's obligation to have risk management system, obligation related to data and data sets, record keeping, transparency, human oversight, accuracy, robustness, cybersecurity, and obligation to have a quality management system. And like mentioned before, if it's a high risk, the product must go through conformity assessment procedure. Just maybe one word also to say that these requirements are defined in the Act quite broadly. So in order to operationalize these requirements into technical operational tools, European Commission already has issued a standardization request to Saenz to two standardization organizations, which now already work on developing the standards to provide operational meat to this to these requirements. So now we are working very hard together with European standardization organizations to develop these standards, which in future hopefully will become harmonized European standards and will give the presumption of conformity in order to meet to comply with the requirements of AI Act, and therefore be able to be brought to the EU market with CE marking. So this is the obligations. Here just again illustrations how it will work all in practice about life cycle approach. Like I said, the pre-market conformity assessment based on the requirements which I just showed for high-risk AI system. Then it will be complemented by post-market supervision by national market surveillance authorities, mostly. So it will follow this decentralized system of enforcement, which we already have at the moment for regulated products. So I think with this, I can conclude and open the floor for discussion. Thank you.
Thank you, Tatiana, for your very comprehensive presentation.
Hello?
Yes. Sorry, I was on mute again. Sorry, Tatiana, for this very comprehensive presentation. It was extremely interesting. Even for myself, I've been, as you know, reading the AI Act thoroughly all these years through, but it was very clear and on point. So I would be happy if there were questions from the audience. Yes, I can see one over there. Could you come closer? I don't know if there is a microphone to go around, but Okay, I'll have to repeat the question because Tatiana can only hear me from there, so from here, sorry. Just a second, the microphone is arriving. Just a second, please.
Thank you for this interesting talk. My question is on the conformity. In the current framework for European conformity marking, the most of the responsibility lies at the system builder or the final product builder who brings the product to market. So when we talk about AI systems, there will be many more intermediaries who will provide components. And I'll come to very specific examples. And in that case, will the component supplier will also be liable for conformity marking, or only this provider or the end builder who is bringing the product into market? For example, let's say there is a product AI-based photo or video editor which has concerns with transparency. Now, I'm the software provider, and somebody else is producing the product or like photo or videos. So here, for the conformity marking, who is legally responsible?
Okay, so I think, Tatiana, I will just summarize the question for you because the audio from the room is not coming to you very clearly. So the question, if I understood it correctly, is a relevant one. It's about standardization obligation, certification obligation, and it says if there are multiple components that are used within the same artificial intelligence system, who is responsible for the certification? Just the one that assembles the final product, or also those that provide the components? Is the question correct? Okay.
Yeah, that's a very good question. It relates to this point which I had said, the interlink with the existing with existing product safety legislation. So overall safety of the product is still responsibility of the final provider. So if you take, let's say, medical device, yeah, so the integration of various AI systems, if there are a few, will be still subject to conformity assessment under medical device regulation. So the provider of medical device will be responsible for the overall performance of the product. So that's the logic. What is, however, important is that during the conformity assessment procedure, which will be based on the existing medical device, if you take medical device as an example, we'll have to take into consideration, of course, requirements specific to AI system component. So it means that the procedure we follow is still of medical device regulation, and overall safe performance of the medical device is subject to the sectoral legislation. What AI Act basically brings is kind of safety net specifically related to AI system or systems, and then this provider of this AI system will have to, the one provides to the overall product will of course have to make sure that this system, AI system, is compliant with the requirement. But overall conformity assessment of the product is then subject to the conformity assessment procedure and responsibility as assigned by the medical device regulation in that case, or any other sectoral legislation.
Okay, there is a second question here from, I will hear it and then repeat it to you, Tatiana, in just a moment.
Thank you. Thank you.
Thank you very much. My question is about, I suppose now when robots will have this AI implemented in their solutions, the behavior of the robot will change over time. This means that when before you had to test or certify the robot, let's say at the beginning, when you want to put it in the market, and now the robot will change the behavior over time, what will happen? So the provider has to make several assessments. How often?
Okay, so the question is, given the implementation of artificial intelligence in robotics will cause robots to change their behavior over time, how often would there be the need to reassess and recertify the system?
Mm-hmm. That's a good question, which also received a lot of attention. So we have a definition of what constitutes significant modification. So basically, if a system is based on machine learning and you have predefined it at the time of initial process of certification, saying how the system could behave, you don't need, of course, of course, if the system continuously learn, you would not basically would need to go then every day to the new certification. That was not the purpose. So unless there is significant modification of the product, which is also comes from the concept which we have in other safety legislation, which is defined, the concept is defined in the Act. So you would not need to recertify. So unless it really changes and if it contributes significant modification, substantial modification, and if this substantial modification understood in the term that while you made this first certification, you haven't really anticipated. So if you provide for that in your initial conformity assessment procedure and in your risk management system, then you would not need to come and to recertify the system.
Okay, I see another question over there. I think we can take this one and then unfortunately we'll have to move on because there is still a lot to discuss.
Yeah, just a quick question. When I read the definition, I am not sure if I could grasp it completely. So my question was, if you just have a simple camera model and then use some classification algorithm to extract some information from visual, is this already falling in this directive? Or do you actually need where does it really start, basically?
Okay, this is a very interesting and complex question about the definition of AI system. This gentleman was asking whether imagine there is a camera system that extracts some information through an algorithm about what it's viewing. Would that suffice to meet the definition of AI system for the purposes of the AI Act or not? Where does the AI Act start? This is the question from this gentleman.
Yeah. I think we have a long recital explaining. So basically for us, AI system is a machine-based system, so kind of, which is developed based on one of the AI techniques. So this is very important. So this must be based on one of AI techniques, which we defined what it is. So one and same kind of outcome, depends how the really system is built. So, but it's one consideration. So we could discuss what does exactly mean, and I encourage you to read long recital. But another thing is, okay, even if it falls into definition of AI system, it doesn't mean that the requirements of AI Act start to apply. And that's what I try to explain with risk-based approach. So definition is quite broad, but it doesn't mean that every software system which will even meet the definition of AI system would necessarily trigger legal obligations. So I think you have to see it in compound together. So.
Okay, thank you, Tatiana, so much for this very thorough and interesting presentation. We could go on the whole afternoon with discussions, but you're very busy and we also need to move on with the schedule. So I would like to have a round of applause for Tatiana. Even if you cannot hear it, there's a full room of people applauding you at this moment. So with the hope of meeting in person again soon, I say goodbye to you, Tatiana, and thank you once more for your thorough presentation and kindness.
Thank you. Thank you, and thank you for your questions, and I'm always open to continue this conversation.
Yes, we'll definitely continue this conversation. Okay, thank you so much. And we resume our presentation. Okay, so now we will start with this, the second part of our workshop together, where we would like to present to you some tools that are already available to find the answer to some of the questions we're already now raising. This is the project RegulAIte, which is also a project funded by the European Commission, that is now coming to a conclusion. I invite the other speakers for today, Rocco and José and Chiara to come on the stage. Please take a seat there. Let me just say a few words of introduction. The project RegulAIte is now coming to an end, but this is actually where our most important outcomes start. The project RegulAIte was funded precisely to bridge a gap in the education of people that are ever more involved in the use of artificial intelligence and in the development of AI-based applications in the sense of the European Commission. And it's a project that brings together Scuola Superiore Sant'Anna, where I am located, where I'm a professor of private law, Chilometro Rosso, represented here by Chiara, Epralima, our partners from Portugal, UCC, unfortunately we don't have our partners from UCC on stage today with us, and Fraunhofer with José. And over 2 years' time, we have basically developed a course that comprises different modules, video courses like that cover the topics of intellectual property, civil liability and AI, product safety and certification, AI risk assessment, AI risk management, and personal data protection under the GDPR, and also the so-called EU data strategy. Nicoletta, I had forgotten, you're also supposed to come on stage. All these people, and also Luke McDonagh, that cannot be here with us today, from London School of Economics, have been working over the last years to prepare a series of video classes to cover the most relevant topics in AI regulation. And you just saw that the notion of AI that is now currently being used encompasses also robotics applications. You heard from Tatiana's presentation that a lot of effort is going in the direction of product safety legislation. The AI Act can be seen as a piece of product safety legislation. You heard that we are about to develop a series of harmonized European standards. So it's very important for an engineer today to know what a harmonized European standard is and how it differs from a standard that is not harmonized, and what are the legal implications of that, and how much that could ease your life, and how much that could impact your life. And so all of these really trigger the necessity to provide you with a good understanding of the various facets, various aspects of technology regulation that impact your life. So we decided to prepare these video courses. They are articulated in a short video and a longer video for each topic that I just introduced to you. They'll be freely available on a platform that will then be presented by Chiara, and that will also be linked on the Eurobotics website for your ease of use. And so you'll be able to access them for free from wherever you are, whenever you want, and get some understanding at a decent level of what technology regulation is and how it is already today going to affect your life, your research, and what you do. Because if you do your work well, maybe you fall within a low-risk AI-based application. In other cases, it could be within the prohibited AI-based systems. And it could be the very same robot companion. But if it's conceived in a way, it could fall within the prohibited application. If it's conceived in another way, it could fall within the low-risk applications and not burden you excessively in any way. So it's really important for you to get a good understanding of emerging regulation, and also to get good lawyers on board in your work early on, eventually in your research-funded projects, and you have a big sample of lawyers here. And also in your research and within your companies and enterprises. So without any further ado, I will leave the floor to our panelists. I'll ask from José to give a brief introduction of the content of his course and why that is relevant to you. And so, please.
Okay, thank you very much. Thanks for the introduction. I'll keep it really brief. The focus is on robotics and AI when we're talking about product safety. So what I go through is the machinery directive and the new machinery regulation. And when you have AI in your system, what kind of flavors of AI could there be, and what will that mean for you? I go through the CE process, I talk about the documentation, I talk about the risk assessment process, and within those processes, when you have AI, what you need to think about. I have a few examples of different situations and how that plays out if something happens. In terms of the validation of your system, things like pressure measurement, force measurement, testing when you have those kinds of robots, and just a few, let's say, small tips and tricks. The simplest one would be you can have AI and it's not considered high risk from the machinery if it's not continuously evolving behavior. So let's say you have a black box, you've trained it, and it's done there once. When you're continuously evolving behavior, it's going to have to be tested by a notified body. They're going to say, okay, so I'll need a standard to test it against. Those aren't available yet. And that's kind of a problem right now. So I would recommend not doing that for the time being.
Okay, Nicoletta, please.
Yeah. Hi, my name is Nicoletta, and I've been in charge with the data protection and compliance bit within RegulAIte. And to put things a bit into perspective, let me present myself for a moment. So I work with technology companies, with startups, spin-offs, and with investment funds as well. And I assist investors in doing their due diligence process. They come to me and ask me if a company is investable from a liability standpoint, and they emphasize a lot compliance when they're looking at data-dependent companies and products such as robotics and software-related products. Also, like even in public funding, the IC Accelerator has very stringent requirements on data compliance. So through these lenses, we've tried to answer some of the common but yet very difficult questions, such as do you need consent? What happens if you cannot get consent to process data, such as when you're using a computer vision solution in a public space? Can you use publicly available data? What built-in safeguards do you need to have? What if you're integrating your hardware, your robot with general purpose AI, such as we've seen recently that Boston Dynamics has done with their Atlas product together with GPT? Do you need to look at your partner's compliance, so on and so forth? So basically, we've also tried to assist teams that are bootstrapping themselves to get a simple but still thorough understanding on these aspects. So if you're curious or just bootstrapping your company or developing a data-dependent product, go check it out.
Yes, please, Rocco.
So
just say a word to introduce yourself as well.
I'm Rocco Limongelli. I'm a solicitor and a researcher at Sant'Anna School of Advanced Studies. My course is about within the RegulAIte, about the EU data strategy. And I think we've discussed the AI Act today. And obviously it's taking a front page. It's what everyone is talking about. But there is so many more things happening within the European regulatory scene. And this includes the Data Act and the Data Governance Act, which are going to be extremely relevant to everyone working in artificial intelligence and robotics. They are bringing a lot of, it's a revolution within itself, to be honest, and they're bringing a lot of new rules in relation to non-personal data. And I think the example I want to give to you today is that of the obligation within the Data Act for companies using and selling robots and artificial intelligence system to users will be obliged to render the data created and collected by that specific robot or artificial intelligence system easily accessible and available to the user. And one example is, for example, in precision farming and farming powered by robotics. In a high-tech farm, you could have an autonomous tractor, ground sensors, and drones. So if each of these products is from a different company, then obviously they cannot interact with each other. What the Data Act allows is for the user to request to kind of unlock these products to be able to gather the data from each one of the products and analyze it in unison to be able to have better data and better analysis of that data. So a lot of things, and Chiara will tell us about how to access all of these courses.
Yes, before leaving the word to Chiara, let me also say a few words about the other topics. The one I have been working on for quite some time now, which is liability. As I mentioned to you at the very beginning, not only the AI Act was approved, but also the revision of the Product Liability Directive, which now encompasses also software. So now it's without question that everything you do falls within the scope of application of this other piece of legislation, which establishes a strict liability of the manufacturer, of the producer of the device. So many of you, or if not most of you, at the moment you bring something to the market to distribute it for profit, you'll be subject to this piece of legislation, which holds you strictly liable, and many of the accidents that today would be due to human error and human actions and human choices will from now on be traced back to the manufacturer, and this piece of legislation expands for sure your potential responsibility. So what I cover in these two courses, the short one and the longer one, is an introduction of the fundamental concepts that you will have to look out for in your research, and especially in the design of your products, because this will inevitably and much more than before affect the way you bring your products to the market and you do business. And finally, I will also say a few words to introduce the part developed by my colleague Luke McDonagh. Some of you might know him personally. Luke has been part of this community already for some years now. We started collaborating on a number of European projects regarding robotics. And when we started, we started with a project called InBots. Maybe some of you were part of that project. It was a very large CSA. And within that project, Luke was among the first legal scholars to address specifically the issues of intellectual property associated with robotics. And he's one of the leading experts. He works at London School of Economics. He teaches at London School of Economics, IP law. And so he, in his video classes, he provides a unique perspective on IP law issues related to robotics. With an expertise that very few lawyers could share. So this is, as per the topics, a broad presentation of the content. And of course, our colleagues from UCC addressed instead the part of risk assessment and risk management, and also in light of the trustworthy AI criteria that you might have learned to know over these years. So after this brief introduction of what we address in the courses, hoping that we got you hooked and interested in watching our videos, I will leave the floor to Chiara to give us a presentation of how you can materially access this content that is available for you for free. So.
Thank you, Andrea. Good afternoon, everyone. I'm Chiara, and at Chilometro Rosso, I worked on the final implementation of the 7 modules that they introduce you on a platform. So we decided to put all these modules and videos on EDAP, EDAP is a free e-learning platform, and it's very user-friendly, very interactive, and you can have access to our course for free, of course, whenever and wherever you want, because it's accessible via PC, tablet, and phone. And each module will have a brief introduction to the topic, and then you will see the learning outcomes of your module. And then there will be one shorter video made by one of our experts, and a longer video that goes deeper into the topic, always made by our expert here today. And then there is a final sum up of the contents. So this is a very important slide because you can take a picture, and if you scan the QR code here, you will be able to download EDAP and subscribe to our course. Otherwise, you can always visit the website edap.com. But the most important thing is to remember and write down or take a picture to our registration code, because when you subscribe to EDAP, you will be asked for the invitation code to have access to the course. So I will leave you a moment to take a picture of this slide. Okay, so here is a brief video. As you can see, it's very easy to subscribe to the app. You just need to insert an email, insert the invitation code. It's a little bit slow, sorry. Okay, and then you can basically subscribe and have access to our course. You will need to create a password for sure for your account. And then it's very easy, it takes you like 2 minutes. And that's it. And then you have access to the course, as you can see here. The platform is very interactive. You will see all the modules on the left, and you can basically start the course and see all the videos made by our experts. Thank you very much.
So, now I think we have some time left, a few minutes left, about 10 minutes left till the end of our session. So I'll be happy to pick any other questions you might have to our panelists, with respect to the content of the courses or any subject matter that you're interested in, or also about the previous presentation of the AI Act. We do not longer have Tatiana connected, but we will be happy to try and answer your questions based on our knowledge of European legislation. Yes, one question over there. If you can have a microphone.
Yeah, so I guess one very small question and one complicated question. The smaller one, could you maybe put the invitation code back up, because I didn't manage to take a picture?
Yes.
That'd be awesome. And thank you. And the second question is, okay, so before healthcare robots, for example, surgical robots, etc., were of course subject to medical device regulation, very heavily regulated, difficult to implement and to get to market. Now, with the prospect of maybe household assistant robots or so that operate in close proximity to humans, right? Maybe even collaboratively on household tasks, for instance. Like they are a technical possibility, or they're within the realm of technical possibility. Would those eventually be subject to similar rigor when it comes to regulation as like what medical robots used to be?
I can, Rocco, you want to try to give an answer? I will also jump in.
Yeah, no, absolutely. I think it's a great question, and obviously, you know, the AI Act is a first piece of legislation. I think, in the future we will see we will have much more clarity. However, the way I see it, unless it falls within the regulation, then you shouldn't regulate it at the moment. Obviously, in the future, social robots that assist in houses with the elderly and so on and so forth might be included in the regulation, but who knows in the future.
Nicoletta, you want to add something? Jose, you wanted to add something, sorry.
Go ahead.
Just shortly, so if I understand correctly, robots anyway are regulated, so they don't have a specific regulation per se, but you have the Machinery Directive, you have the GDPR, you have the Data Act, you have cybersecurity requirements, so there's that.
Yeah, I was going to say something along the same lines, that basically don't think now the AI Act is doing that. If you're talking about a robot for consumer areas, there's already the product safety and the machinery directive, and the machinery regulations already talking about AI. The machinery regulation came out about a year ago, I want to say, and that was before the AI Act came out, and there was this original idea to have them really strongly intertwined. We're talking about the same thing. They decided against that. Right, so there's a bit of a decoupling that took place. So that also makes it a little bit simpler. So don't get too worried that it's adding extra things right there in that situation. But in the machinery regulation, it's already talking about the AI, and the question is, it actually comes down to the same processes. Do your risk assessment, what's happening, what are the risks, where are you using AI, and how are you using it, and how does that affect, even before we had the AI Act, and even before we had AI, there are lots of other reasons why consumer robots that are physically moving around in human spaces aren't much bigger than a Roomba these days. Yeah, those are other reasons, right? It's it's energy, inertia. These are inherent risks when I have babies crawling on the floor and cats running around doing what they want. And I think that's sort of where other problems are really originating from, and it's not really AI is your biggest problem right now. Yeah.
So I would also add a few words. I agree with everything what was said. There is already a lot of regulation that applies. However, it's almost certain that the AI Act will apply also to medical applications, and some will also fall in the high-risk category. So inevitably, there will be some additional layer of legislation and requirements, some of which still have to be fine-tuned because, as Tatiana was pointing out, standards still need to be adopted on certain aspects. I don't know if you're aware of what a harmonized European standard is. It's a standard that is adopted by a European standardization organization upon a request of the European Commission. And when you comply with a harmonized standard, there is a presumption that you met the safety requirements. So typically, compliance with the standard is not required. Actually, compliance with the standard is never required, but typically compliance with the standard per se is not sufficient to ensure the safety of the product. When it comes to a harmonized standard, it does. So the European Commission will be making an effort over the next years to adopt a large amount of harmonized standard to help implement the AI Act, because guessing exactly where and how the AI Act will play out today, it's not so obvious because so much needs to be implemented from now on for it to really demonstrate its scope and potential. Any other questions? One over there.
And if I may add something,
Yes,
I think that the question whether the Act applies or not is a very good one, and one that will be asked more and more, and this requires an internal assessment basically. So everyone, I think everyone, doing robotics, doing software, doing AI, they will have to assess if the Act applies or not. So yeah, that's the status quo.
So another way of saying what Nicoletta is saying, you need lawyers early on in your design phase. So there are not many expert lawyers and advanced technologists as of today around, so save our names. Just kidding. Please.
Yes, is the legislation retroactive? Things that are already on the market, do they have to be recertified?
I don't think it is, but it's
I mean,
it is?
it's not retroactive per se. So, you know, retroactive means that if you got on the market a product that will need to be certified under the AI Act, then they're going to be able to fine you. That means retroactive. So that's not going to happen. But if you got a product on the market that needs to be certified under the AI Act because it's an high-risk product, when the AI Act comes into force, you will need to certify it. It doesn't matter whether it was on the market before the AI Act came into force.
Nicoletta, you wanted to add something?
No, I agree with Rocco. So basically, everyone that is doing AI as of the entry into force will have to be compliant if the act applies. We have this window period of 2 years mostly, so everyone can get compliant. And I think it would be sort of discriminatory not to be like that, because it would create an imbalance, for example, between existing companies, like we've seen all the cases with OpenAI right now. So it would create not very nice, it would create a disadvantage, for example, between EU companies and US companies, so on and so forth. So it's only fair for it to apply to everyone that's placing AI products onto the EU market.
And if I can just add, maybe you're interested in this, you can have a look at Article 85 of the AI Act, which will tell you when and which parts will come into force. So from the publication on the official journal of the European Union, which is basically now, then the high-risk category requirements will come into force 36 months later. So you got a lot of time to prepare. Prohibitions will come into force 6 months later, so they will be into force very, very soon. And the general purpose AI parts of the regulation will come into force 12 months after publication. All the rest will be 24 months.
Okay, any other questions?
Yeah.
Okay. Yes.
In one of the previous slides, I saw there was a mention of post-market surveillance. Now, most of us will already be knowing about post-market surveillance for medical device, but could you make some comments or give some examples hypothetically that what AI product could be another candidate apart from medical device per se for post-market surveillance?
Okay, so post-market surveillance in the context of the machinery regulation is more like, on the one side, as a manufacturer, I need to have some kind of process and efforts in place to see how my product is being used and if things are happening, right? And on the other side, there's the market surveillance, which is notified bodies within the European Commission. And these are things that are triggered by events. So there's an example in the video that I say somebody is using a robotic system that was brought by an integrator, and there's an injury. So once you have a workplace injury, you're going to have, at least in Germany, somebody come in, that's the Berufsgenossenschaft, these are the occupational health insurance providers. And they're going to start asking questions, right? So they're going to say, okay, who made the machine? Show me the CE mark. With the documentation, then they're going to call the manufacturer. They're going to say, show me all of your documentation that you're supposed to have. And this is all classic machinery regulation, machinery directive stuff. And that's what's involved there, and then if they are completely non-compliant, if the CE mark is a load of bullshit, then they'll see that. That's the sort of this challenge that, it's self-compliance, and then it'll come into play, and then, they can do all kinds of things. They can force a market recall, you have all these different options that are available within this realm of market surveillance, and the idea is that the manufacturers are also doing some kind of due diligence to keep this in mind. It's in their interest. They want to do it. If they find out about something, they're going to want to do some changes, some updates before they get recalled completely from the market, right? So that's what's happening there, and that's sort of that context outside of the healthcare.
Okay, I think we have another question over here.
Yeah, I just want to make sure I've understood something properly. You're saying that the full compliance will turn up in 2 years, obviously for the high risk. Product life cycle in robotics, the development time can be 5 years, 6 years, and you're then asking us to develop a product for which the standards are not available to meet regulation, which we don't know exactly how it's going to get implemented, and that it's going to come in 2 years' time with where the product is probably already being tested now, if it's going to launch on the market in 2 years. So you're asking us to then effectively stop the development of the product in order to wait for the standards to turn up so that we can work out whether or not it's compliant or not, because it's high risk to put that on the market because 6 months later you might have to take it off again. Is that the effect that you were looking for?
So,
wait, that we were looking for, David, is a little bit, we're not the MPs.
No, I appreciate, no, you're quite right. My apologies, I shouldn't have.
So yes, the first thing I wanted to say is that we are not the European Commission and we're not representing the European Commission.
Don't kill the messenger.
So, we're just trying to explain to you what is coming into force. And yes, there might be such kind of problems because, but the thing is, so I have some skepticism about some aspects of the AI Act. But when you try to regulate something so complex such as artificial intelligence intended in such a broad scope, it's very hard not to get something, let's say, wrong or less than perfect. To some extent, I think that risk is unavoidable because the timing of legislation and that of technology development are not very easily aligned. So, but I think the European Commission could not renounce regulating advanced technologies. The question is whether what they did is good, and because it's so complex to assess, it will take time. And for sure, there are aspects that will need to be addressed and reconsidered. When I started with law school, I was working on capital markets regulation, and back then, it was during the financial crisis, and I was making a similar comment in the spirit to what you just made, just referring to capital markets regulation. And my professor in the United States told me, Andrea, remember, regulation is not a battle, it's a war. Meaning it's not fought just once, it's fought many times over and over again. So you cannot get the exact and best regulation possible at the first iteration. And we definitely need to fine-tune the legislation and all the regulatory initiatives. But this is ever more even a call on you to be aware and become part of this very complex debate. Now there will be an AI authority that will be created by the European Commission. There will be standards that need to be developed, and on all such instances, you will have a possibility, if well organized, as robotics, as an association, to have a say and participate in the debate. So this is demonstrating why it is so important that you as engineers become aware of all the implications that this emergent regulatory framework is bringing upon you, so that you can participate actively in the debates around it. Because this is just the beginning, it's not the end, and so much needs to be done to shape European regulation in the subsequent years. So this is an encouragement to start this dialogue and bring it forward.
Yeah, so can I echo that? Because I
yes.
think to the people in this meeting, it raises the fact that EU robotics, at the very least, should be trying to coordinate some of that, because clearly if the standards are impacting on our whole community and this is how this act is going to get implemented, we actually need your help in trying to make that representation and trying to do that. So as a call to action, really, for everybody in this room to get engaged in this. Thank you.
Yeah, and to follow up on that, David, EU robotics is involved in the discussion with the European Commission. We were involved with standardization. That was the discussions with Andrea. We've known about this for a while, and it's like driving into a brick wall. On the other side, what I could say to kind of calm down this theoretical discussion is to say we're talking about really high-risk stuff, and where do we really want to have AI in really high-risk stuff? So that comes back to the original point, only as much as necessary and as little as possible, right? So you know, keeping that in mind, it's also something that from a roboticist point of view, I don't really need to have AI in everything, and yes, it'll make my life harder, so you need to think about that. Yeah, there are consequences. And you know, we were talking in TG safety. Do I really need to have AI in safety? It's not making me safer. So things to think about.
I think just to add on that, a very quick one, you need to remember that regulations have the objective of regulating, of course, but in doing so, as the AI Act, I'm sure will do, it's one of the objectives it has, it increases trust in technology. And by increasing trust in technology, it makes the industry bigger. And just think about the GDPR. Before the GDPR, it was the old Wild West in social media and social media company using data as they wanted without any stringent rules. And now we are suffering from that. And I'm sure, if you're a roboticist and you've done some experiments, specifically with social robotic, privacy is one of the issues that comes up again and again and again and again. And I think, with robotics, with the AI Act, we want to avoid that. We want to create more trust in technology.
Okay, so thank you everyone for joining us today. It was a great pleasure. I love the discussion. And this, as we said already, is just the beginning. And please be in touch. Here are all our contacts, and we're very happy if you reach out to us. So thank you again, and have a nice rest of the day.